Hi, I'm Jacob Stein, and I am an asset protection attorney. I'm a partner at Aliant's Los Angeles office, and I have been practicing asset protection planning for about 25 years, representing all sorts of debtors facing lawsuits, judgment collections, and government actions, and helping them protect their assets. In this quick video, we will talk about protecting assets of a California couple. So if we are representing, and if you are a couple who is living and married in the state of California, what do you need to be aware of? Well, California is a community property state, and what that means from a debtor-creditor standpoint is that if one of the spouses is being sued, all of the community property assets are exposed to that lawsuit. There is this mistaken belief that we see very often, both from our clients, from other attorneys, from accountants, that community property is owned 50% by each spouse. And that is not true. Community property is divided 50-50. So on death or on divorce, right, community property is divided 50-50. It is owned 100% by each spouse. I understand the math does not work. You're dealing with lawyers. With lawyers, math does not need to work. Community property has what's known as a coextensive ownership interest. So each spouse owns and controls 100% of the community property assets. And what that means is that if one of the spouses is being sued and there is a judgment coming down against that spouse, what are the assets that the creditor can reach? Well, the creditor can reach all of that spouse's assets, and turns out that spouse owns all of the community property assets. So the creditor, let's say, of the husband cannot go after the wife, but they can go after all of the community property assets because the husband happens to own all of the community property assets. So one of the first planning points that we address with a couple that is living in California where only one of the spouses is exposed to a threat of litigation or a debtor-creditor type of a situation is we look to separate their assets. We look to terminate community property, right, and transmute community property, transform it into separate property. So usually this is accomplished with a fairly simple, straightforward written agreement. In California, this agreement is known as a transmutation agreement, and you're transmuting, changing the character of community property to separate property. So we are going to look at all of the assets that our married couple owns. We are going to divide those assets equally, so each one gets 50% of the value of the assets. Right, so the half goes to the husband, half goes to the wife. And if, let's say, the husband is the one who is going to be sued, okay, so we've protected half of the assets that has gone to the other spouse, to the wife, but we'll also cherry pick which spouse is going to get which asset, right? So if the husband is the one who is likely to be sued, the husband is going to get either those assets that are easy to protect, usually liquid assets because we can move them offshore, or that the husband is going to get those assets that are not desirable to that plaintiff or creditor that's going after him, because maybe these assets are exempt under state law from creditor claims, like assets in a retirement plan. So a transmutation agreement accomplishes an equal division of the assets by value. We pick and choose who is going to get what. And for a married couple, it's a fantastic starting point to protecting their assets if only one of them is going to face some sort of a creditor issue. I hope you found this video somewhat educational. I am Jacob Stein, and I'll see you next time.